Welcome back to the High Court Report. Today we dive into Hamm versus Smith, a case that will fundamentally change how every capital defendant in America can prove intellectual disability and escape execution. This IQ score showdown will confront when multiple IQ tests may determine life or death. The court scheduled oral arguments in this case for December 10th. Here's what you need to know. The Supreme Court will decide whether courts must consider all IQ test scores together or whether a single low score can qualify someone for constitutional protection. This decision affects every death penalty case going forward.
This ruling may require immediate changes to your litigation strategy and expert testimony approach when attempting to convict a person with an intellectual disability. We'll tell you exactly what to watch for in oral arguments, how to prepare your cases for either outcome, and what steps to take before this decision drops. Because once the court rules, people need to adapt your approach immediately.
Before going any further, I want to remind our listeners about our upcoming first ever mailbag episode on Black Friday, November 28th. I'm really excited about the chance to interact with you, the audience. This term delivered blockbuster after blockbuster. You've got questions. You've got theories about how these cases connect. You want to know what I'm watching for in oral arguments, or which decisions could ripple through your practice area. Now,
Send your questions and comments by Monday, November 24th. Email us at scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. I'll read your message on air and dive deep into the answers. What's your take on this term's biggest constitutional battles?
let's start with what makes Hamm versus Smith so critical. Joseph Smith scored 75, 74, 72, 78, and 74 on 5 different IQ tests. Alabama courts looked at all 5 scores collectively and denied intellectual disability protection. Federal courts focused on that single score of 72 and granted protection. The Supreme Court will now decide which approach controls nationwide.
So, the central question: do courts evaluate multiple IQ scores as a complete dataset, or do they treat each score independently with measurement error? Your answer to that question determines whether hundreds of current death row inmates live or die.
And that decision carries immediate consequences for anyone working in capital litigation today. Let's break down exactly what this means for your practice.
Okay, let's look at the question at issue in plain English. When someone takes multiple IQ tests to prove intellectual disability, do courts look at all the scores together, or can one low score alone save their life? Think about it this way. Smith scored 75, 74, 72, 78, and 74 on his 5 IQ tests. Alabama courts said 4 out of 5 scores show you're not intellectually disabled. Sorry, you still face execution. But federal courts said that one score of 72 might actually mean your true IQ falls below 70, so you qualify for protection.
The Supreme Court will decide which approach wins nationwide. Do courts treat IQ testing like batting averages, looking at overall performance across multiple attempts, or do they treat it like pass-fail exams, where one passing grade saves you regardless of other failures?
Now, here's what this may mean. If the court sides with Alabama's collective approach, you'll need to prepare comprehensive IQ testing histories for every capital defendant. No more relying on a single favorable score. You'll need to explain why all test results, taken together, support your intellectual disability claim.
But if the court sides with Smith's holistic approach, parties may focus on expert testimony about measurement error and test validity. Your litigation strategy shifts from comprehensive score analysis to targeted expert explanation of why any qualifying score should trigger constitutional protection.
The constitutional text comes from the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
The Supreme Court ruled in 2002 in Atkins versus Virginia that executing intellectually disabled individuals violates this cruel and unusual punishments clause. But here's the critical part for practitioners. Atkins left implementation details to state governments, creating the current confusion about testing methodologies.
What you need to understand: different testing approaches can yield completely opposite results for the same defendant. That's why this case matters so much. It will standardize the approach nationwide and determine how you structure every future Atkins claim.
So, whether you defend or prosecute capital cases, this decision will require immediate changes to your expert witness preparation, your testing protocols, and your evidentiary strategy. The court's ruling will create new constitutional mandates that every jurisdiction must follow.
Let's start with the horrific crime that brought us here. In November 1997, Joseph Smith heard that a man named Dirk Van Dam carried $1,500 in cash. Smith decided to murder Van Dam for that money.
The attack proved absolutely brutal. Police found Van Dam's body in his pickup truck in a wooded area of Mobile County, Alabama. Van Dam died from 35 different blunt force injuries to his body. Smith mutilated him with a power saw, and Van Dam died with massive brain swelling, rib fractures, and a collapsed lung.
Smith robbed Van Dam of about $140, far less than the $1,500 he thought Van Dam carried, plus some boots and work tools. A jury convicted Smith of capital murder and sentenced him to death.
Now here's where the IQ testing becomes crucial. Throughout his life, Smith took 5 different IQ tests. The scores came back as 75, 74, 72, 78, and 74. In chronological order, under Alabama law, defendants must prove intellectual disability by a preponderance of the evidence, which typically means showing an IQ of 70 or below.
Smith filed a federal habeas petition, claiming intellectual disability under Atkins. The federal district court held an evidentiary hearing where both sides presented expert witnesses. Smith's experts argued that his lowest score of 72, when you account for standard measurement error in IQ testing, could actually reflect a true IQ as low as 69. They emphasized that courts should look holistically at all evidence of intellectual functioning, not just count scores above and below arbitrary cutoffs.
But Alabama's expert, Dr. Glenn King, testified that having 5 IQ scores obtained over a lengthy period of time by different examiners under different conditions actually provided compelling evidence that Smith's true IQ exceeded the intellectual disability threshold.
The federal district court sided with Smith. The judge found that Smith's lowest score, accounting for measurement error, could mean his IQ sits actually as low as 69. The court granted Smith's habeas petition and vacated his death sentence.
The 11th Circuit affirmed that decision. The appeals court ruled that, under Supreme Court precedents in Hall v. Florida and Moore v. Texas, Smith needed to prove only that the lower end of his standard error range equals or falls below 70.
The Supreme Court granted certiorari to resolve this fundamental question about how courts should evaluate multiple IQ scores. In Atkins claims the circuit courts have split on this issue, with some requiring holistic assessment and others allowing consideration of all scores collectively.
Let's break down how each side frames this constitutional battle, starting with Alabama's position. Alabama's first major argument centers on state discretion and federalism. They emphasize that Atkins explicitly reserved to governments the task of developing appropriate ways to enforce the constitutional prohibition against executing intellectually disabled defendants.
Here's what this means. If Alabama wins, states will retain broad discretion to set evidentiary standards for intellectual disability claims. Defense attorneys will need to master each jurisdiction's specific requirements rather than relying on uniform federal constitutional standards. Alabama points out that the Supreme Court offered no definitive procedural or substantive guides in Atkins and left states with the flexibility to craft their own evidentiary frameworks. They argue that Alabama's approach, requiring defendants to prove intellectual disability by a preponderance of the evidence considering all available IQ scores, fits comfortably within the state discretion.
Their second argument attacks what they call the 11th Circuit's improper one low score rule. Alabama contends that the federal courts misread Supreme Court precedents in Hall and Moore as mandating that any single IQ score within the margin of error automatically satisfies the intellectual functioning requirement.
If Alabama wins this argument, a party to a criminal proceeding may not be able to rely on a single favorable IQ score anymore. It'll require comprehensive expert testimony explaining why multiple test results taken together support intellectual disability findings. Alabama emphasizes that this approach violates fundamental burden of proof principles. Instead of requiring Smith to prove his intellectual disability, the 11th Circuit essentially shifted the burden to Alabama to rule out the possibility that Smith's IQ might fall below 70, which Alabama argues creates an impossible standard.
Alabama's third argument focuses on the lack of national consensus for expanding Atkins protection. They point out that when the Supreme Court decided Atkins in 2002, state laws generally protected only offenders known to have an IQ under 70. Alabama argues that extending protection to cases like Smith's, where multiple scores exceed 70, goes beyond the range of offenders covered by national consensus.
Smith's legal team takes a fundamentally different approach, emphasizing the scientific reality of IQ testing and constitutional requirements for individualized assessment. Their first argument centers on what they call holistic assessment. Smith contends that courts must evaluate multiple IQ scores holistically rather than simply counting scores above and below arbitrary thresholds. This holistic approach requires considering expert interpretation of test validity, measurement conditions, and other evidence of intellectual functioning.
If Smith wins, expert witness preparation becomes central to every Atkins claim. You'll need psychologists who can explain measurement error, test validity, and statistical uncertainty in language that judges and juries understand. Smith emphasizes that Hall versus Florida specifically held that defendants must present additional evidence beyond raw IQ scores when those scores don't definitively establish intellectual functioning. Alabama law itself requires courts to look at all relevant evidence with no one piece of evidence, such as an IQ test score, being conclusive.
Smith's second argument focuses on the proper application of Supreme Court precedents. They argue that the district court correctly applied both Alabama law and constitutional requirements by holding an evidentiary hearing, making credibility findings, and ultimately crediting Smith's experts over the state's witnesses.
Process matters. If Smith wins, expect more extensive evidentiary hearings in Atkins cases, with greater emphasis on expert testimony and credibility determinations rather than mechanical application of test score thresholds.
Smith's third argument attacks Alabama's score counting approach as scientifically unsound and constitutionally impermissible. They argue that simply tallying scores above and below 70 ignores the scientific reality that IQ tests contain inherent measurement error, particularly for individuals whose scores fall within the borderline range.
The federal government filed an amicus brief supporting Alabama's position, making three key constitutional arguments that could prove decisive given this court's composition.
First, the United States emphasizes that Atkins preserves essential state discretion in defining intellectual disability standards. The government argues this discretion preserves the traditional role of legislatures in setting the bounds of criminal sanction and remains consistent with how the Constitution otherwise cabins judicial power.
Second, the United States makes a scientific and practical argument about multiple IQ scores. They contend that multiple IQ scores often say more about a person collectively than anyone does alone, comparing this to polling where multiple data points provide more accurate results than isolated measurements.
Here's what to watch for when oral arguments take place on December 10th. Pay attention to Justice Roberts and Justice Kavanaugh's questions about federalism and state discretion. Their positions will likely determine the outcome.
Listen for questions about practical implementation. If the justices seem concerned about standardization across jurisdictions, that favors Alabama's approach. If they focus on individual fairness and constitutional protections, that favors Smith.
Watch for scientific questions from about IQ testing methodology. Their comfort level with statistical evidence could influence how the court views competing expert testimony approaches.
Most importantly, note any questions about burden of proof. If justices ask whether defendants or states should bear the risk of uncertain test results, that tells you how they're thinking about the fundamental constitutional question. The Supreme Court may fundamentally reshape intellectual disability determinations in capital cases. The decision between collective score evaluation versus holistic individual assessment may determine the fate of hundreds of current death row inmates and every future capital defendant. Mark your calendar for December 10th. We'll host oral arguments and analyze them afterwards.
The broader impact extends beyond individual cases. This decision will influence how the criminal justice system balances scientific evidence with constitutional protections, how states implement federal constitutional mandates, and how courts evaluate complex psychological testimony in life or death contexts.
We'll provide detailed analysis of oral arguments when they occur and comprehensive coverage of the court's decision. But don't wait for our analysis. Start preparing your practice now for either outcome.
Thanks for joining us for this analysis of Hamm versus Smith. The court's decision may reshape capital convictions nationwide. Make sure you're ready.
In our next episode, we cover FS credit, a case that must answer whether Supreme Court precedent prevents people from using civil rights lawsuits to get future protection when they've already been punished under the same law they're challenging, and whether Supreme Court precedent bars Section 1983 claims by plaintiffs even where they never had access to federal habeas relief. We'll break it all down for you. Thanks for listening to the High Court Report. Follow, rate, and share the podcast if this content helps your practice. Connect with us on LinkedIn or email with your questions and insights. Talk to you soon.